Hello and welcome to Topic 9, Lecture 2. And in this lecture, we're going to start introducing the concept of the right to privacy. So in this lecture, we're going to first define what we mean by the right to privacy. Then we're going to look at where the right to privacy is in relationship to the Constitution. In other words, where does the right to privacy originate from? And then we're going to take a look at the first major right to privacy case, which is Griswold versus Connecticut. Next week, we'll be digging in more deeply to the right to privacy, looking at the landmark case Roe v. Wade that has to do with abortion rights, and then looking at how abortion rights have changed over time, and then looking at the way that the court extends the right to privacy to other issues. So today, this week, we're just beginning the start of our discussions on the right to privacy. Now, the right to privacy is more than being free from unreasonable search and seizure. A lot of times when I talk to my students about right to privacy, initially they say, oh, well, the right to privacy is that you have the right to not be searched by a cop in an unreasonable or an unwarranted way. That right springing forth from the Fourth Amendment. And while privacy does include your private space to not be searched by police officers, it's more than that. We'll be learning more about the Fourth Amendment specifically in a few weeks. The right to privacy, though, moves beyond just this right to be free from unreasonable searches. You should think about it more as a general right to privacy, or as Justice Brandeis spoke about it in his famous dissent in the Olmstead case, which you'll read about in the textbook, where he says that essential to the pursuit of happiness is the fundamental right to be left alone. That there's some things that we do in our life that government should not be able to intrude upon. This right to be left alone. Keep in mind, this is another example, great example of how we have an idea that's planted in as a seed in a dissent. And so the court did not agree with Brandeis's understanding of privacy as this right to be left alone. But he puts it in the dissent, and then 30 years later, that seed that is planted in that dissent germinates and really becomes the basis for our understanding of right to privacy in the United States. The right to privacy, as you'll see in the chapter that you'll be reading a little bit this week and next week, is the freedom to make private choices about your body, in particular, private choices about reproduction. And so right to privacy includes the issues of contraceptives, using contraceptives, and also the right to have an abortion. The right to privacy extends to privacy in sexual matters. So the right that you have to have consensual adult sex with who you want to have consensual adult sex with. You'll be reading about the sodomy laws that were overturned by the Supreme Court in the name of the right to privacy. And also the right to get married, as we see in the Obergefell case. It also deals with the right to die, drug testing, privacy in the information age, etc. And so the right to privacy is much more than just the right to be free from unreasonable search and seizure. So one of the seemingly controversial aspects of the right to privacy is the fact that the Constitution does not explicitly mention this right. In fact, the word privacy does not appear in the 7 articles of the Constitution, nor does it appear in the Bill of Rights. And so there's always been a question about, well, do we actually have a right to privacy? And if we do have a right to privacy, where does this right originate from constitutionally? And so in the next couple of slides, we're going to be taking a look at where the right to privacy is founded within the Bill of Rights. So in the textbook, you're going to be reading about the substantive due process doctrine, okay? And it's a substantive due process doctrine that is the doctrine that's used to establish not just the right to privacy, but other rights as well, that rights that are not explicitly stated in the Constitution. And so in the textbook, you'll read that in the early 1900s, the court creates this thing called the substantive due process doctrine. And it's going to sound familiar because when we did the chapter on the incorporation of Bill of Rights, you'll remember that one of the ways in which, or the way that the Bill of Rights was incorporated to the states was through the Due Process Clause. Now, the Due Process Clause is in two places in the Bill of Rights. It's in the Fifth Amendment and it's also in the 14th Amendment. And just to refresh your memory, that in the Fifth Amendment, it says, that nor shall any person be deprived of life, liberty, or property without due process of law. And the 14th Amendment says that nor shall any state deprive any person of life, liberty, or property without the due process of law. And so remember when we learned about the incorporation of Bill of Rights, they basically were saying that in the 14th Amendment, it says states can't take away people's liberty. And that was the avenue for incorporating the Bill of Rights to the states. Well, when it comes to finding liberties that aren't explicitly stated in the Constitution, the Due Process Clause has been used because it has the word liberty in it. And so when it comes to the substantive due process doctrine, that this doctrine is basically implies the existence of rights that are not enumerated in the Constitution, because it provides an expansive understanding of that word liberty. And that's kind of why it's called the substantive due process doctrine, because this doctrine tries to identify and define the substance of liberty. And when you say the word liberty, well, what kind of liberty are we talking about? What kind of freedoms are included in the due process clause? And so let's look at how the court expand or gave substance to the word liberty in the due process clause. So the substantive due process doctrine provides the foundations for locating privacy in the Bill of Rights. And there are a couple of cases that your textbook talks about that are sort of early preludes that or cases that establish the substantive due process doctrine and therefore serve as a sort of like prelude or foundation for a method for locating liberties that are not explicitly stated in the Bill of Rights or the Constitution. The one case that your textbook talks about is Lochner v. New York. This is an interesting case. It's a case about a New York law that prohibited employees of bakeries from working more than 10 hours a day and more than 60 hours a week. So it's basically a law that limited the number of work hours of workers in bakeries. And in Lochner, Joseph Lochner, he owned a bakery, and he was like, hell no. He's like, I have this right to, ask my employees if they want to work 12 hours a day, 14 hours a day, 20 hours a day. And that the employees have this fundamental right to contract with me to determine how many hours they want to work. And so that was the argument that Lochner made to challenge the New York law, and the Supreme Court agreed with Lochner. He basically said that there are, through the Due Process Clause, there are some of these fundamental liberties that are not explicitly enumerated, and one of those fundamental liberties is the right to contract. Now, it's kind of funny because when you read in your textbook, there's talking about the right that an employee has to contract with their master. And so it's like, well, is that really a free choice contract or whatever? But they use the substantive due process doctrine to locate this right to contract. For my students out there who took the Sex, Power, and Public Policy class, you'll remember that there was a similar case that came to the Supreme Court, and the name of that case was Mueller v. Oregon, and that was a case that limited the number of work hours for women. And if you recall that while the court in Lochner says that men have a right to contract, this freedom to contract, they said that the state's interest in protecting women actually superseded the right that women had to contract. So just wanted to, for those out there who might be like, oh, that Baker case sounds sort of familiar, it might be because we talked about Mueller v. Oregon in our GSW class. Another a case that your textbook talks about that uses the substantive due process doctrine is the case Meyer v. Nebraska. This is a case about a state law that was enacted after World War I that forbade schools from teaching German and other foreign languages to students below the 8th grade. So it was sort of like this anti-German sentiment. Yay, pro-United States, right? And the court struck that law down, basically, saying, and make sure that you read in your textbook that, they say that, look, the right to contract isn't the only right that is, a part of this substance of liberty in the due process clause. They basically said the right to acquire knowledge. So in this case, the right for parents for their kids to acquire knowledge by learning a new language, that's included. The right to bring up your children, the right to marry, to enjoy any liberties that are necessary to the pursuit of happiness, right? And so it really sort of like, whoa, this is a really kind of like opens the door for a very expansive understanding of liberty. Now, as you'll read in your textbook, this was a really controversial doctrine. And in fact, the second half of the Most Dangerous Branch really focuses on the controversy that revolves around the substantive due process doctrine. It was controversial for a variety of reasons that you'll read about. One is that it was used in the name of capitalism, laissez-faire capitalism. So it basically gave free birth to employers and to owners of factories and corporations to basically do whatever they want, right? That they have this freedom to, create working hours, to create working conditions, to have children work, have women work, whatever, and that the government, the heavy hand of the government, shouldn't enter in and do that kind of regulation on the free marketplace. So it's controversial for that because there's a lot of times when the state sort of does need to step in, like we shouldn't have 5-year-olds working in mines, or maybe we shouldn't have pregnant women who are working 12 hours a day. It's kind of an old-fashioned sort of understanding, but there was this understanding that women needed and children needed to be protected. It also led to court activism, and so the court was basically striking down laws left and right because they said these laws violated our understanding of liberty. And a sense of encroaching on the police power of the state. The states have the power to regulate business and regulate working conditions, and the substantive due process doctrine, sort of made it difficult for the state to exercise the police powers that they have emanate from the 10th Amendment. And as you're going to see in even the more modern cases that use the substantive due process clause, and you're going to see this in the Most Dangerous Branch, that it leaves it open to the justice's own opinion to decide what is in fact a fundamental liberty. So on the one hand, that might be a positive thing because you want to not be so constrained by just the liberties that are written in the Bill of Rights that can be pretty constraining, and it also doesn't give our society a chance to have a more sort of living understanding of liberty. What we thought about liberty in the 18th century is really different than what we think about liberty today. And the substantive due process clause allows us to sort of have this more sort of flexible understanding of liberty. But it also means that justices get to use their own opinions. Maybe some justices say the right to contract is a liberty, but other justices are like, where are you getting that? And why do you think that is a fundamental liberty necessary to live in an ordered democracy? Now, the substantive due process clause was abandoned by the court in 1930, in a large part because of the New Deal and the need for economic recovery. And so coming out of the Great Depression, we had all these laws that were basically trying to revive the economy in the United States that were coming from the federal government in partnership with state governments. And so the court kept striking them down, and there just came a point where it was like, in the name of liberty, it really constrained the power of the federal government in order to do economic recovery. In the 1960s, because we had this, sort of shifting understanding of liberty and freedom as we have social movements and the rise of the civil rights movement and other sort of activist movements, women's rights movement, gay rights movements, that there was this desire that the substantive due process doctrine could be revived and used to establish the right to privacy. And so let's take a look at that. Okay, so the first right to privacy case that comes to the Supreme Court is Griswold versus Connecticut, 1965. And what this case deals with is what's known as Little Comstock Acts. So what are those? Well, so Connecticut and many other states, they had laws on the books that basically made it a crime to use contraceptives, to get contraceptives and to use them. It also made it a crime for somebody to basically counsel somebody about the use of contraceptives and to write a prescription for them to get contraceptives. Now, this law had been on the books since the late 1870s, but in 1961 it was still on the books in Connecticut. It was still the law of the land there, and so individuals who used or distributed or counseled people on the use of contraceptives, it was a criminal offense. Now you might think, what's the point of this kind of law? Well, in the United States, in the late 1800s, there was a move in the United States to basically there was a concern about immorality. And so there was this guy, his name was Anthony Comstock. He was the postal general for the United States government. And that basically he was personally really concerned about the spread of immorality. He lived in New York, and he would walk around and he would see prostitutes, and he would see, obscenity, and he would see things in his job as working in the mail with the postal service. He was like, there's so much smut out there. There's so much pornography. There's so much activity that's leading this country down the path of immorality. And he wanted to put a stop to it. And so he advocated for a law to be passed at the federal level. It was called the Comstock Act. That made it a crime to use the United States Postal Service to send any obscenity, and also to send any information or actual contraceptives, manuals about how to use contraceptives, sex toys, or any abortifacients. That was a crime, to use the Postal Service to do those things. And a lot of states adopted those. They were called the Little Comstock Acts. Those were the laws that were adopted at the state level. The thinking is that people could have sex using contraceptives, that it would lead to immorality, that men and women could have sex outside of wedlock with no consequence because they could use a contraceptive. Men and women within relationships could have as much sex as they wanted to without concerns about reproduction. And there was a concern about that having sex just for pleasure was a vice. It was an immorality, and that the state had an interest in stopping that. You can actually see that sign that the guy is holding there. It says, that's a picture of Estelle Griswold. She's the director of Planned Parenthood in the state of Connecticut, and she opens a Planned Parenthood clinic in New Haven in order to challenge the law that's on the books in Connecticut. And this is a picture from the protest that took place outside of the Planned Parenthood clinic. The law is the law, or is it? Morality is in danger, right? The immorality associated with using contraceptives. And so Estelle Griswold opened a clinic in New Haven with a friend of hers who was a doctor, and with the sole purpose of challenging this law. And on the first day that it opened in 1961, married women were coming to get information about contraceptives, and they were given prescriptions to get the contraceptives. And Estelle Griswold and her friend Buxton, the doctor, they were arrested, they were found guilty, and they were each fined $100. And then so they challenged that law, saying that it violated a person's fundamental right to privacy. And the Supreme Court agreed to hear the case. Okay, so the question before the court in Griswold versus Connecticut is, does the Constitution protect the right of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraceptives? And in a 7-2 decision, the Supreme Court said yes, that Connecticut law criminalizing the use and distribution and the counsel on the use of contraceptives was unconstitutional because it violated the right to privacy. That in his decision, and you'll read it, and I really encourage you to read the decision in the textbook, plus the concurrences and the dissents, that the court says that even though it's not explicitly stated, the Constitution does protect a general right to privacy. This right is found in the various guarantees within the Bill of Rights, and that when you take those different liberties in the Bill of Rights together, it creates this zone or this shadow, a penumbra that establishes the right to privacy. The right to privacy is deemed a fundamental right, which basically means that the state has to have a really good, a compelling reason for interfering in a person's right to privacy. And they said that the Connecticut statute conflicts with the exercise of this right and is therefore null and void. Judicial review. So, what are the takeaways from Griswold? Well, for one, it creates a constitutional right to privacy, and so this is the first case to create that. But keep in mind that Douglas does not use the substantive due process doctrine to do this, and I'll tell you in a second why. Instead, he finds, as I mentioned in the last slide, the right to privacy in the shadows of the Bill of Rights. And when you read his decision, the court's decision, you'll see that he says that when you take the First Amendment's right to association, the Third Amendment, the right to be free from having soldiers quartered in your home, the Fourth Amendment, right to be free from unreasonable search and seizure, the Fifth Amendment, the private right that you have that the state can't force you to speak, and the Ninth Amendment that basically says that just because a liberty is not enumerated in the Constitution doesn't mean that that liberty doesn't exist. He says that when you take those together, that's where we find the right to privacy. You might be saying, well, why did he just use the substantive due process doctrine? The reason is because Douglas, in previous cases, that he stood opposed to the substantive due process doctrine. He was against it. So he's like, well, I want to find a right to privacy, but I can't use the substantive due process doctrine. So where am I going to find it? He created this sort of like clever way of getting around it with the finding it in the penumbrums of the Bill of Rights. Establishes it as a fundamental right. It can only the state can only limit privacy rights if the law survives strict scrutiny, that the state has to have a compelling interest to invade upon that liberty. And what's another takeaway from Griswold is there's a lot of disagreement to where this right exists in the Constitution. And in a second, we'll take a look at Table 10.1 from your textbook. And that's why I really want to encourage you to read the concurrences, because that's where you find this disagreement of where the right to privacy is located. Make sure you pay attention to the dissents that the dissenters say that it's not in the Constitution. The words aren't there, so it does not exist. And that is a position that is still alive and well on the Supreme Court today. Justice Thomas, the former Justice Scalia, and most likely we'll see Justice Amy Coney Barrett. That remains to be seen whether or not she thinks there's the right to privacy is found within the Due Process Clause of the 14th and 5th Amendment. And then another dissent is that, look, one of the dissenters says this is a silly ass law. This is just stupid law. But it's not for the courts to overturn this law. The place to do that is in the legislature, not in the courts. And so that was the other basis of the dissent. Make sure you take a look at it. So here's a look at the table in your textbook. Douglas and Clark, they locate the right to privacy in the penumbras that emanate from the from the Bill of Rights. Goldberg, Brennan, and Warren, they've always found it just in the Ninth Amendment, which, in the concurrence makes a really good argument for why the right to privacy and other liberties as well can just be found in the Ninth Amendment. That says that just because the liberty isn't enumerated doesn't mean that it doesn't exist. Harlan and White, they find it in the Due Process Clause and utilize the substantive due process doctrine in order to establish the right to privacy. And Blackstewart, that there's just no general right to privacy that's found in the Constitution. Words ain't there, doesn't exist, don't manufacture it. So where does that lead us? Well, the Griswold versus Connecticut establishes the right to privacy. The big question is, what is covered by the right to privacy? How far does the right to privacy extend? It extends to contraceptives, but the big question is does the right to privacy extend to abortion? And many people are eager for the court to take up this issue. And the court answers this question in 1973 when they agree to hear Roe v. Wade. And so that's where we start next week, Roe v. Wade, the changes to the interpretation of Roe v. Wade, and then we'll look at the other the other subjects that are covered by the right to privacy. All right, thanks for your time, and I'll talk to you again soon.